Section 1, Rule 130. Object as evidence. Object as evidence are those addressed to the sense of the court. When an object is relevant to the fact in issue, it may be exhibit to examined or viewed by the court. Section 2, Rule 130. Document evidence. Documentary evidence. Documents as evidence consist of writing or any materials containing letters, words, numbers, figures, symbols, or other modes of written expression offered as a proof of their contents. Section 3, Rule 130 of original document must be produced. Exceptions. When the subject of inquiry is the contents of a document, no evidence shall be admissible other than the original document itself, except in the following cases. A. When the original has been lost or destroyed or cannot be produced in court without bad faith on the part of the offeror. B. When the original is in the custody or under the control of the party against whom the evidence is offered, and the latter fails to produce it after reasonable notice. C. When the original consists of numerous accounts or other documents which cannot be examined in court without great loss of time, and the fact sought to be established from them is only the general result of the whole. D. When the original is a public record in the public custody of a public officer or is recorded in a public office. Section 4, Rule 130, Original Document. A. The original of document is one of the contents of which are the subject of inquiry. B. When a document is in two or more copies executed at or about the same time with identical contents, all such copies are equally regarded as originals. C. When the entry is repeated in the regular course of business, one being copied from another uh, at the near at the time of the transactions. uh, all the all the entries likewise equally regarded as original. Section 5, Rule 130. When original document is unavailable. When the original document has been lost or destroyed or cannot be produced in court, the offer upon proof of its execution or uh, or existence and the cause of its unavailability without bad faith on his part uh, may prove its contents by a copy or by a recital of its contents in some authentic document or by the testimony of witness in the order state. Section 6, Rule 130. When original document is in adverse party custody or control, if the document is in the custody or under the control of the adverse party, he must be reasonable notice to produce it. If after such notice and after satisfactory proof of its existence, he fails to produce the document, secondary evidence may be presented as in the case of its loss. Section 7, Rule 130, Evidence admissible when original document is in public record. When the original of a document is in the custody of a public officer or is recorded in the public office, its contents may be approved by a certified copy issued by the public officer in custody thereof. Section 8, Rule 130, Party who calls for document not bound to offer it. A party who calls for uh, the production of a document and inspects the same and inspects the say the same is not same obliged to offer it as evidence. Section 9, Rule 130. Evidence of written agreement. When the terms of agreement have been reduced to writing, it is considered as containing all the terms agreed upon and there can be between the parties and their successors in interest. No, no evidence of such terms other than the contents of written agreement. However, a party may present evidence to modify, explain, or add to the term of the written agreement if he puts uh, in in his pleading an intrinsic ambiguity, mistake, or imperfection in the written agreement. B. Failure of the written agreement to express the true intent and agreement of the parties thereto. C. Validity of the written agreement. D. The existence of other terms agreed to by the parties of such successor and interest, interest, interest after the execution of the written agreement. The term agreement includes will. Section 1, Rule 131. Burden of proof. Burden of proof. It is a duty of a party to present an evidence uh, on the facts in issue necessary to establish his claim or defense by the amount of evidence required by law. Section 2, Rule 131. Conclusive presumptions. The following are instances of conclusive presumptions. A. Whenever a party has by his own declaration, act, or omission intentionally and deliberately led another to believe a particular thing uh, true true and to act upon such belief, he cannot he cannot in any litigation arising out of such declaration, act, or omission be permitted to falsify it. B. The tenant is not permitted to deny the title of his landlord at the at the time of the at the time of the commencement of the relation of the landlord and tenant between them. Section 3, Rule 131. Disputable presumption. The following presumptions are satisfactory if the uncontradicted may be contradicted and overcome by other evidence. A. The person is innocent of crime or wrong. B. That an unlawful act was done with an unlawful intent. C. That a person intends the ordinary consequences of his voluntary act. D. That a person takes ordinary care of his concern. When that evidence willfully suppressed would be adverse if produced. F. That money paid by one to another was due to the latter. G. That a thing delivered by one to another belongs to the latter. H. That an obligation delivered up to the debtor has been paid.